Hello, welcome to PPL 518 Alternative Dispute Resolution 2. This is our first lesson and we'll be looking at a general introduction to arbitration. So before we start the lesson in earnest, let's just refresh our memory. So what does alternative dispute resolution, what does it mean to you? I'm sure you have heard the word several times. If you were asked to give a simple definition of alternative dispute resolution, what would you say that it means? Not, no high sounding definition in your own words. So the first thing you have to bear in mind is that alternative dispute resolution is made up of two different terms. So you have the first term, which is alternative, that's one. And then you have the second, which is two words, dispute resolution, that's two. So what does alternative mean, or what are other words that you can use, synonyms for alternative? I'm sure you can think of many. Well, you could say alternative is synonym is substitute or another, right? And dispute resolution, what does it mean? In simple terms, it simply means resolving of disputes. So it means that if we were to use, the synonyms that we just coined, it means that alternative dispute resolution is another way of resolving disputes. To the next quick question, another way from what? What another, when you speak of another, what are you talking about as a substitute to what? So if you were to think of the word dispute, or think of what you want to be, a lawyer, what comes to your mind for resolution of disputes is the court system, litigation. So alternative dispute resolution is another way of resolving disputes outside of litigation. That's a simple way of defining it. And there are four major types of ADRO. There are other forms, but there are four major ones. So you have negotiation, you have conciliation, you have mediation, and you have arbitration. Some are not binding. So for instance, negotiation is not binding. But for the purpose of PPL 518, we will be majoring on arbitration. Arbitration, that's what PPL 518 is about. Okay, the objectives of this course. You can see we have quite a number of objectives, but let me just point out that all the objectives for this particular topic we cannot take in this lesson. So what we have done is to break this lesson into two. So we have lesson 1A and lesson 1B. In lesson 1A, we will take the first three objectives, which are to analyze various definitions of arbitration, to discuss the features of arbitration, and to differentiate between arbitration and litigation. Okay, in the next lesson we'll look at the benefits of arbitration compared to litigation, some arbitral institutions, and applicable laws. So we hope that at the end of this class we'll be able to understand the first three objectives that I have. Okay, so now to our lesson proper. First question, if we are going to be looking at arbitration in this entire course, we need to understand what arbitration is. So that is the main question. What is arbitration? How would you define arbitration? Okay, now the main law guiding arbitration in Nigeria is the Arbitration and Conciliation Act, which we call ACCA. Now the ACCA, funny enough, does not define arbitration. There's no definition in the ACCA for arbitration. So the question that comes to mind is why? Why is the ACCA silent on arbitration? Is it that the drafters, it was an oversight on the part of the drafters, or is there something that they had in mind by not putting the definition? We will answer that towards the end of this lesson. But the fact that there's nothing in ACCA does not mean that definitions don't exist. So we have picked four definitions that we will look at in this lesson, and then we will also look at how Nigerian courts have defined it. So let's start first of all from the definitions that we are taking from sources of law, secondary sources of law. So Brown and Marriott is a text on arbitration, English text on arbitration, but very well written and very widely acclaimed. So Brown and Marriott defined arbitration. Then we have the Hallsbury's Laws of England also defined arbitration. Words and phrases legally defined have a definition for arbitration. And then we'll look at the simple dictionary meaning from the Oxford Shorter English Dictionary. So let's quickly go and Marriott. So Brown and Marriott say that arbitration in English law may be defined as a private mechanism for the resolution of disputes which takes place in private pursuant to an agreement between two or more parties, under which the parties agree to be bound by the decision given by the arbitrator according to law after a fair hearing, such decision being enforceable at law. Quite a mouthful, but note that there are many features of arbitration in this definition. What I've tried to do in this for this lesson is that for each definition, we will be highlighting some of the features of arbitration which the definitions make mention of. That's the whole a part of what our analysis is about. So let's look now at Brown and Marriott. You can see I highlighted that arbitration is a private mechanism, and then it comes into existence pursuant to an agreement between parties, and the decision given by an arbitration is given after fair hearing, and the decision is enforceable at law. Those are the major features of arbitration that Brown and Marriott have pointed out in their definition. Now let's So Oxford Shorter English Dictionary simply says that arbitration is uncontrolled decision, the settlement of a question at issue by one to whom the parties agree to refer their claims in order to obtain an equitable decision. Short, to the point, fine, but how many features of arbitration are covered in this definition? First is settlement of a dispute. Second is parties agree. Third is equitable decision. It doesn't go into detail whether it is private or who will give the decision, that being the arbitrator and all of that. So it doesn't specify as much of the features of arbitration as Brown and Marriott does. And then another issue, what does the Oxford Shorter English Dictionary mean by uncontrolled decision? Who is controlling or not controlling the decision? If you remember from the definition we got from Brown and Marriott, arbitration is by agreement of parties. Agreement of parties is cardinal to arbitration. We will talk about it again when we look at the features of arbitration. And even in this our Oxford Shorter English Dictionary, they say parties agree. So to what extent can we then say that the decision of an arbitrator is an uncontrolled decision? So that kind of brings in some uncertainty and makes it a bit this the English dictionary definition of. But let's go on. So words and phrases legally defined says that arbitration is the reference of a dispute or difference between not less than two parties for determination after hearing both sides in a judicial manner by a person other than a court of competent jurisdiction. Note, it also talks about a hearing and in a judicial manner. Brown and Marriott says fair hearing, equitable decision, and then it talks about a person other than a court. Brown and Marriott specify an arbitrator. So you can see the features. Some of the features are also here, but again, not as much as Brown and Marriott. Very short, to the point. Reference of a dispute or difference between not less than two parties for determination after hearing both sides in a judicial manner by a person or persons other than a court of competent jurisdiction. So court adopted in NNPC and Luton Investment. Note I said Supreme Court. So what that means, because of the doctrine of stare decisis is that Hosbury's laws of England's definition of arbitration becomes a standard definition in Nigeria. Okay, now to the second definition. In Onoselugu and Afribank, an arbitration agreement, actually what the Court of Appeal was defining there was an arbitration agreement. But in their definition of an arbitration agreement, you can see features of arbitration being mentioned. So they said that an arbitration agreement is where two or more persons agree, first feature, that a dispute or potential dispute between them shall be resolved and decided in a legally binding way, second feature, by one or more impartial persons, third feature, in a judicial manner, fourth feature, upon evidence put before him or them, fifth feature. Can you identify the features? Let's go back and point them out. Some of them, are a bit different from the way we mentioned them. So, for instance, one or more impartial persons is the same as the arbitrator in Brown and Marriott's definition. In a judicial manner, the same as in Hosbury's and words and phrases legally defined, and the same as saying that arbitration is quasi-judicial. Upon evidence being put before him or them, fair hearing, rules of natural justice. So you see that the features are there. Now, let's look at four fundamental. Let's differentiate between what we have been talking about as features. Maybe we should say characteristics, but for the purpose of this one, four things you must look for if you were faced with a scenario and you had to identify whether the dispute resolution method that was being used was arbitration or not. Four fundamental features that you must look for. If these features are not present, then it's not arbitration. First is that it is an alternative to court. Again, refer to our definition. It is a private mechanism. Remember, we said that court is public. So it is a private mechanism means that it is an alternative to, it is a private mechanism. Yes, then alternative to court. Parties don't go to court, So parties control their proceedings in private. There's no reference to court. Please let me point out, when we talk about it being an alternative to court, and I've said there's no reference to court, it doesn't mean that the court may not be called upon from time to time to give orders. As you will see when we go on in the lesson, in this topic, you will find out that in some cases the court may be called upon to make a ruling or make a pronouncement. However, that does not mean that the issue is now being resolved by the court. It just means that because the court is the enforcing arm, the court will be called upon to do its bit for enforcement, but the court does not descend into the arena and resolve the dispute. So arbitration, if there are no hitches along the way, arbitration is fully an alternative to court. Then, as I said, it's a private mechanism for resolution of disputes. It is not public. It is unlike the court system. Third is that it is selected and controlled by the parties. Remember what we said, that it is by agreement of the parties. So parties control the proceedings. This is very important. And it's not only in just the theoretical features where we are talking about now, but if you were faced with the facts of the case, you must be able to identify that parties control their proceedings. Parties will decide which institutional arbitrator to use if they decide to use an institutional arbitrator. They will decide which law should be applicable. They will decide how long the hearing will take. They will decide who the witnesses will be. They will decide location for resolution, for hearing, whatever. Parties control everything. Now, you will also find that in some cases, the arbitrator or arbitrators may, make suggestions. They remain suggestions until parties agree. If parties do not agree or acquiesce to the suggestions, they are just suggestions and they cannot be binding on the parties. Very important. And finally, arbitration is final and binding. The fact that it does not take place in court does not take from the nature of arbitration as a final and binding means of alternative dispute resolution. Remember when we were talking at the beginning, when we were refreshing our memory, we said some forms of alternative dispute resolution, like negotiation, are not binding, but arbitration is binding and arbitration is final. Please note that when we say it is final and binding, it doesn't mean that it cannot be appealed. An award may be subject to appeal if parties agree for that to happen. However, the fact that a matter is subject to appeal does not mean that it is not binding. What makes it binding is that the arbitral panel are done with it, and that's it. If a party wants to take it further to appeal, he has to go through some other mechanism, not through the same arbitrators who came up with the award. So those are the four fundamental features of arbitration that we must bear in mind. It will help us in distinguishing, in distinguishing between when a matter is being resolved via negotiation or something, or when a matter is not arbitration but looks like it. Look for these four features. If they are not all present, it is not arbitration. Alternative to court, private mechanism, controlled by the parties, and final and binding. Important. So we have looked at a total of, well, we'll say 5 definitions of arbitration. Can you remember the definitions we looked at? Let's go over them. One, we looked at Brown and Marriott. We looked at the Oxford Shorter English Dictionary. We looked at Hornsby's Laws of England. We looked at words and phrases legally defined. And then we looked at the not NMC, Onosenugu and Afribank Court of Appeal decision where they defined an arbitration agreement. Remember that we also mentioned that arbitration was defined in NMPC and Luton, but I'm not counting it as one of the definitions because what they basically did was to adopt Hornsby's laws. So, okay, having looked at all those definitions, which one would you prefer and why would you prefer the one you prefer? Now, it's important to note in answering this question I've asked, that there's no right or wrong. What I just need you to do is to think about the definitions and why you like one more than the other. Okay, so for instance, you could say, oh, I like words and phrases legally defined definition best because it is short and straight to the point. Fantastic. However, does it do enough justice to the definition? Does it mention all the features? Note that none of the definitions that we looked at mention all the features. The features we were able to distill, we got from all of them together. So no one is particularly right and no one is particularly wrong, with the exception, of course, of that word or phrase, uncontrolled decision, which I pointed out in the Oxford English Dictionary definition. Personally, I prefer Brown and Marriott's definition simply because it is the most comprehensive. It's a bit of a mouthful, yes, I agree, and may be difficult to remember everything, but for the purpose of defining by identifying the features, Brown and Marriott goes to the furthest extent. Okay, now let's go to what was our first question at the top? ACA being silent on a definition for arbitration. Question now and before, the question was, why do you think that the ACA was silent? I remember I wondered aloud, is it because the draftsmen didn't think about it? Now, this is why I think the ACA was silent on the definition. Let's go to your rules of construction under admin law, your Latin rules of construction. Inclusio unius est exclusio ulterius. Inclusion of one is the exclusion of the other. In defining arbitration, where you expressly make reference, or not just arbitration, any word, where you make express reference to a particular term, by making express reference to that particular term, any term that is maybe to the contrary is expressly excluded. That is the rule. And that is what the ACA tried not to do. So, in being silent, they stopped people being bound by a particular rigid definition of arbitration, allowing for the fact that arbitration is a fluid concept. You will see that when we talk about the benefits of arbitration, flexibility. So, allowing for parties to define arbitration to suit their particular context. So, by being silent on a definition, parties can now source other definitions. Okay, that is what the AC has done. So, really, in being silent, the AC actually strengthened the possibility of defining arbitration, and that is quite commendable. It's because the ACA is silent, for instance, that we were able to look at other definitions and then distill features out. Okay, so that is commendable. Now to another question. Having spoken so much about arbitration, defined it and all of that, and made reference to its features, is it preferable to litigation? We will deal with this question seriously in the next class when we start talking about the benefits of arbitration vis-a-vis litigation. But just for the purpose of this our discussion, let's look at two different schools of thought. Professor Schmidhoff, on one hand, says that arbitration is better than litigation, conciliation better than arbitration, and prevention of disputes better than conciliation. So, as far as he is concerned, arbitration is better than litigation. Then, on the other hand, you have Fouchard. Fouchard says that arbitration is rudimentary because parties submit to ordinary individuals without requisite qualification except being chosen to sit as arbiters. That to Fouchard is a major defect of arbitration and why arbitration should not be preferable to litigation. Now, looking at these comments, we can conclude from Professor Schmidhoff that as far as he's concerned, better not to have any disputes at all. Okay, but if you have any disputes, a better option than litigation would be arbitration. So, as far as he is concerned, arbitration has more benefits than litigation. Now, go back to Fouchard. Fouchard says that arbitration is rudimentary. Why? Because he says that the arbitrators are ordinary individuals and not properly qualified. The question that comes to mind is, one, is law the only qualification for resolving disputes? If it is, how come our parents at home, our elders and all that are not all lawyers? That's the first question. Secondly, when you are faced with a case that requires specific expertise, for instance, the Microsoft case where the issue was licensing of source codes for Linux, how many judges know what source codes are, for instance, and how many judges can really tell what the technical issues will be as to tie it to IP to be able to give an equitable decision. Remember, we said that arbitration, the goal of arbitration is to arrive at an equitable decision. So you see that in some cases, the kind of expertise that is needed necessitates the engagement of arbitrators who may not necessarily be lawyers, and they will do a fantastic job. So for that reason, Fouchard, his opinion is a bit lacking because one does not have to be a lawyer to do a good job as a dispute in resolving disputes as an arbitrator. And that is again is even one of the benefits of arbitration, the fact that you are not tied to a lawyer. Okay, so to my mind, arbitration is preferable to litigation, but it's not because arbitration does not have its own disadvantages. So again, that's another thing for you to think about. Is arbitration preferable to litigation to you, and why? Remember that it's not in every case that arbitration will be applicable. Sometimes litigation may be a better option. So, second assignment for you to take home. and think about. Can you remember what our first assignment was? Our first assignment was which of the definitions, the 5 definitions that we looked at, do you prefer and why do you prefer it? Looks like our discussion class will be very interesting, on Wednesday. So feel free when we come together for our discussion to raise your points and let's, rub minds together and learn. So we have been going on for the past 25 minutes, and some of the things we have learned are, first of all, the simple meaning of ADRO. We looked at that. Then various definitions of arbitration and an analysis of the various definitions. And then we looked at the fundamental features of arbitration. Remember the capital 4 that we talked about. Can you remember private, alternative to court? Can you remember the other two? Binding. Okay, that we said that it is also final and binding and quasi-judicial. Okay, now, so those are the fundamental features of arbitration. And then we also talked about some other characteristics that we distilled from the definitions given by the various authorities that we looked at. So we learned those, and then we talked about whether it is preferable to litigation in the first place and why it may be preferable or it may not. So if you have any questions, please feel free, as I said before, to bring it up during our discussion forum. Our discussion forum will take place on Wednesday. That's the 30th of September. Feel free to bring it up, and feel free to download this video and listen to it as many times as you possibly can until you understand everything. Remember that at the end of the week we have a quiz. So during the quiz I will be asking you questions. So in order to be sure that you know everything that you're supposed to know, feel free to ask any questions about any part that is not clear, and of course we will trash it. So I look forward to